Hi everyone, today I wanted to discuss with you briefly about the introduction of copyright law. Get an overview of what copyright law is all about, and if this is your first lecture in this series, I think it is also a good beginning that you can just get a holistic view of what we consider when we are talking about copyright law, and then you can jump on to the other lectures that are a part of this series. So, as I've mentioned here, the first question is what is copyright? Uh, Copyright, as the name suggests, is that there is a right with you, and this right is related to the copy. So, if you have come up with work A, it could be like literature, dramatic work, musical work, artistic work, it could be a cinematographic film or sound recording. This is your work over which the law, copyright law, gives you a right that in case anybody wants to make a copy of this work, they have to take the permission from you, otherwise, it will amount to infringement under the act, right? So, the next question that we consider is why we need such a right, like why we need copyright to begin with. And a very crucial point in this understanding would be that initially, like in the ancient ages, people were all hunter gatherers. They were going and doing their labor in collecting uh, the raw material which will feed their family. And as more and more time came to people to think about things, as people got time to think about things, they sat down and they made use of this intellect for the growth and development of not only himself but the society at large. So right now there are multiple uh, highly classic books that we read, like we read Shakespeare, we look at the paintings such as the Mona Lisa, we have architectural figures such as the Leaning Tower of Pisa or the Eiffel Tower that we look at and admire about the intellect with which men are gifted. And so copyright tries to protect this kind of intellect in the society, and the entire purpose of protecting it is because the law is basically providing you with a formal framework for the ownership of the knowledge that has been developed, with the intention that you will be sharing this knowledge for the benefit of the society at large. So, further, we have come to understand intellectual property as the fuel of the present economy. The importance of intellectual property has been recognized around the world as IP is the knowledge or information with commercial value. Countries such as US and China, Israel are leading in the world. They have a very high GDP because their IP protection is very high, and this is happening because they have strict laws. There are laws that recognize the input, the labor put in by the author who has created the work, because of which they want to go and register their work in that country. So that is what intellectual property is aiming to become in the present society. We see that over 10% of GDP in Australia and USA, about 8.5% in Korea, about 6% in Netherlands is due to copyright industry. So we see how uh, copyright or intellectual property as large has come to the forefront since we are dealing with copyright. Mainly, we will not neglect the aspect of what intellectual property entails, like, so whatever creation that is coming out of your intellect is given the um, position of property. So property that you have right now, like your home, is a tangible property, but intellectual property is an intangible property. There is a lot of debate about giving intangible intellectual work the respect of property, and this is dealt with in theories given by these three very heavily renowned philosophers of ancient time. Like Locke says, if a person has put in his labor into any kind of thing, he is rightful to claim ownership over the same. And so if a person has put his labor, effort, skill, judgment into creating a work, he should get a property ownership or title over that property, and if anybody is enriching out of that property, the rightful owner should get benefit out of it in terms of royalty, if you say so. You have to be mindful that these theories were given at a time when intellectual property was not even perceived or conceived by these men. So it is very much in reference to tangible property that we are reading with respect to intangible, because that's our purpose, right? Next is a theory given by Hegel, who says that every person has a personality, and in order to assert his freedom and will into the world, he has to acquire certain property which is acknowledged by other members of the society in order to fully attain the presence of his personality in the world. And hence, if a person A has come up with a work of any of these type, he should rightfully get a title over that particular work. Next is Bentham. His utilitarian theory basically tells you that you should adopt the path that gives the greatest happiness to greatest number of people. So this greatest happiness to greatest number of people, and this could be read to the essence that if your work is being given protection, then you are releasing it into the society, and the masses will benefit out of this work. um, Out of this work. So for any society to culturally or uh, politically developed, there has to be dissemination of information at large, like all these theories given by these people over wide scale, read at wide scale, because of which many prominent movements and assertion of right took place. So this is the understanding that there is a quid pro quo between the society getting information and the author getting a certain belief or support from the state that his work will get rightful recognition, and his dues against the time and effort he has put into creating that work will be rewarded. So coming to the concept of IP, as we were discussing, IP is of two types. Like IP is of copyright, and the other type is industrial property. And internationally, copyright is dealt with in Berne Convention, and industrial IPs are dealt with in Paris Convention. Industrial IPs can be further divided into things like patents or layout designs, undisclosed information, GIs, trademarks. So everything falls here. These are the two classifications that are present, and these conventions are managed by WIPO. Earlier it was WIPO, and then after TRIPS came, it the responsibility of WIPO was merged with WTO, and India is a member of both these member organization. So we are bound by these international commitments that we have made under Berne Convention and Paris Convention, and no understanding of copyright can be read in isolation to the Berne Convention. Next, we'll be dealing with general principles governing copyright law. The first is that copyright is a statutory right. We have the subject matters given in section 13, and whatever is recognized there, if your work is not falling within that realm, then it will not get protection. We see in section 16 where it is recognized that no person shall be entitled to copyright or any similar right in any work, whether published or unpublished, otherwise than under and in accordance with the provisions of this act or of any other law for the time being in force, but nothing in this section shall be construed as abrogating any right or jurisdiction to restrain a breach or trust of confidence. So our main content from this provision is that in accordance with the provision of this act, which suggests that the right is statutory. Next is a formality for obtaining copyright. As such, it is believed, it is in general parlance, that copyright comes into existence the moment the work is created. There is no mandate to get your work registered. However, it is coupled with a lot of complexities and technicalities that we will be discussing, and it is bogged down by factors such as publication, fixation that needs to be considered, whether your work is actually capable or eligible to be given copyright, when in fact at the outset it is mentioned that there is no eligibility as such, right? So next we discuss that what is the function of modern copyright system. So first function is production. If you have incentive, if you are giving incentive to the authors in form of copyright, it will foster creation and public communication of original expression, which will concern a broad range of political, social, cultural and aesthetic matters. And copyright will promote democratic character of civil society, hence it's important. Next is structural function of copyright, that is, copyright is vital to maintaining the democratic character of public discourse in civil society. It supports an independent market based sector of authors and publishers, as the government, administrators, and private patrons do not meddle in their expressive content. Right? Next, we have development function, and the correlation can be done in the example that we have discussed earlier about how USA, Israel, China are doing well because of high IP protection that is accorded there versus us. Next, we discuss about the balancing act of copyright. See, what the state wants to do is maintain this quid pro quo. It wants all the authors that are coming up with works to publish the work to the public, so that there is dissemination of intellectual work to the masses, and in return of this it is giving it the protection. However, there might be certain cases where the author just does not find it suitable or reasonable to put his work out there in the public, and he just wants to keep it to himself, or he is restricting the number of copies that are available in the market, which affects the information that is available in free market. In these cases, we see that the government has come up with option of compulsory licensing or statutory licensing that is there. Other situation is that there is incentive for the government to restrict the content in public domain. Like the bigger the public domain is, the more beneficial it is for the society. What is public domain? It is the information that is not protected by copyright, and this information can be exploited by this masses to create more new information. So the government would want public domain to be as large as possible, and hence it has come up with numerous exceptions to what will not amount to infringement, and it is given under section 52. And for the sake of our discussion, and I find it reasonable to discuss what is mentioned in section 52. It says that the following act shall not constitute an infringement of copyright, namely a fair dealing with any work not being a computer program for the purposes of private and personal use, including research. So if you are using it for yourself or for research, it is not infringement. Criticism or review, whether of that work or of any other work. So criticism of review, like even if you are doing it on social media or on some print media, and you are quoting what the person has said and how you disagree with whatever is written, is not an infringement. The reporting of current events and current affairs, including the reporting of a lecture delivered in public, even this is not infringement. So the explanation here is the storing of any work in any electronic medium for the purposes mentioned in this clause, including the incidental storage of any computer program which is not itself an infringing copy for the said purposes, shall not constitute infringement of copyright. So any of the above work which is recorded in electronic medium will not amount to infringement, right? Then there are certain other categories that are included, like the observation, study or test of functioning of the computer program. These are specifically related to computer programs. Then we have other work, like if there is the reproduction of any work for the purposes of judicial proceeding or for the purpose of report of judicial proceeding. So whatever live law or bar and bench are doing is not infringement, right? And we also have the case of EBC versus DB Modak, where we see that one cannot claim copyright over judgments that are given. Reproduction of any work in a certified copy, reading or recitation in public of reasonable extract from a published literacy or dramatic work. Reasonable extract means not the entire work is being recited, right? It's just some one chapter, one poem or whatever. Next, we have what are the subject matters of copyright that are protected, and it is given under section 13. I have a separate lecture for this. It covers literary, dramatic, musical, artistic work, along with cinematographic film, sound recordings. Next, Copyright vests in original work. The condition for originality is limited to this LDMA work, which is primary work, and this work has to be original. And this work, like CFSR, is derivative work, and hence the condition of originality is not imposed on it. Next, we have the principle that copyright does not vest in idea. This explains the idea expression dichotomy that we have discussed in another lecture, that whatever you are thinking in your mind or you are communicating to some person is not worthy of getting copyright protection, because as discussed that the government would want the public domain to be as large as possible. You have to convert it into some form of expression. You have to, with be it like write a book, or you present it through a play, you write a lyrics to a songs, or you create an art around that subject to get beyond that stage of idea and claim copyright over it, right? Next is copyright and independent creation. This principle suggests that even if two individuals have come up with exactly the same work but independently, then they are both worthy of getting copyright protection over the same. Next, we have the point that copyright is a bundle of rights, and here I have mentioned that the rights include reproduction, adaptation, distribution, public performance, broadcasting, cable casting rights, rental rights. So, whoever owns the copyright to a work, so right, work is LDMA CFSR. Whoever owns copyright to these works get the bundle of rights, which are these uh, 7 rights that are available. And there is also moral rights that are associated with a work that a person has created, and moral rights ensure that nobody, like, the general idea is, if you have created a work A and it has been sold to person B, you lose control over this work. Like, B can sell it to C, D, E, or just put it down dustbin. He can do whatever he wants, but moral rights ensure that this person B cannot distort, mutilate, or modify your work in a manner that infringes your integrity or your identity associated with the product. So moral rights gives the original author certain right over his work even after the first sale has been done. So this is the principle of first sale principle that is very much applied in the US, right? And since there are multiple rights available and associated with a copyright, you can split these rights. You can give one right to, like, you can give you have written a story, you can give one right to a dramatist to create a drama out of it. You can give another right to a producer to create a movie out of it, and it's okay. You can do and get license money or royalty money out of both the agreements that you are undertaking at the same time. Then it is important to understand that copyright is a negative right. It prevents other people to infringe your copyright. It is prohibiting others from exploiting your work. Next, copyright is a right with limitation, and this limitation comes in the form of time, that it is life plus 60 years only that your work is protected. Suppose that it is not. There are certain restrictions that are given in the form of fair use, like given in section 52, as we discussed here, that in these circumstances it will these acts will not amount to infringement. Next, there is geographical limitation to your right. The owner of a copyright in a work is protected by the law of the country against acts which are restricted by copyright, which are done in that country. So you cannot go directly to country A when your right is protected in country B to claim that your copyright has been infringed, right? Next, it is a non-voluntary licenses, that the laws of some country permit the use of copyright protected works without authorization, provided that fair remuneration is paid to the owner of copyright. Then what will you do if country A believes you can infringe on somebody's copyright? Like, it will not amount to infringement till the time you have paid reasonable to money to the author of the work. Then what will you do? So this can also happen. Next, in instances when there is overlap between copyright and industrial design, as discussed in section 15. So So section 15 tells us that copyright shall not subsist under this act in any design which is registered under the Designs Act. So there is one situation where the design is already registered under the Designs Act. Another situation is that it is capable of being registered but is not done so. But the moment that design has been produced more than 50 times by an industrial process, it will lose its right to get copyright protection under the act. Right, so this is what overlap between copyright and industrial design talk about. Then concurrent copyright is discussing in the form that there can be multiple copyright since it's a bundle of right, there can be simultaneous version of copyright protections that are existing, like one with the book as we discussed here. So the person who has written the book will have copyright, the person who has created the drama will have, dramatist will have copyright, the person who has made the movie, the producer will have copyright, right? And the remedies given against infringement of copyright are in the form of civil, criminal and administrative remedy. Next is the principle of what amounts to eligibility for protection in India. This we have discussed in section 13.2 in one of our last videos, which clearly tells us that both published and unpublished works are protected under Indian Copyright Act. And for a published work to get protection, it has to be first published in India, or if it is published outside India, then the person who is the author is a citizen of India, or if the author has died on the date of making of the work, he was a citizen of India. Sorry, at the time of his death. So if the work is published outside and he has died, so at the time of his death he was a citizen of India. Next, in the case of an unpublished work other than a work of architecture, the author is at the date of making of the work a citizen of India or domiciled in India. So if the work is not published, then the person has to be citizen or domiciled in India. Next, it is saying other classifications are given for cinematographic film, like if a substantial part of the film is infringement of copyright of another work, like if you are basing a movie out of a book and you have infringed, like you have not taken the permission of the author, so you will not get protection out of this. So I briefly just wanted to discuss with you about the what copyright law is and why we need it.